you for coming out on this cold, wet December night to join us for the December meeting of the Rehoboth Beach Board of Adjustment. This evening, the board will consider two cases, and we're going to consider them in this order. Our first case will be to consider a motion for rehearing regarding 19 Baltimore Avenue, a case which we first heard and decided on September 20th, 2019. In that case, the building inspector ruled that the dimensions of hotel room balconies, which the owner sought to erect on the property, would have to be included in the gross floor area of the building. The property in question is a commercial property. We, at that time, affirmed the decision of the building inspector. The owner has filed a motion for a rehearing in that case, and as I said, that would be the first case that we considered tonight. The second case we are going to hear tonight is a request for a variance from the zoning code requirements that there be 2 off-street parking spaces for each dwelling located on a lot in a residential zone. The property in question is 38 Oak Avenue. So public comment will be allowed on the Oak Avenue variance request, but not on the motion for a rehearing. So that's what we're going to be doing. Let's take care of our formalities first. Let me do the roll call. I can see that Walt Cassell is here. I'm here, Jerry Capone, Linda Kaufman, our vice chair, and Lou Katz. Barry Brandt is not here. That means we have 4 of the 5 members. We have more than a quorum. 3 members are needed for a quorum, so we are able to proceed tonight. And Madam Clerk, would you please advise us about the notifications for the 2 cases in question tonight?
The agenda was published and posted in City Hall and on the city portal on December 9th, 2019. It was amended on December 13th, reposted on the 13th. It was also sent out from the city portal on December 13th. The public notice for case number 119-10 was posted on November 21st, 2019 in City Hall and on the city portal on the same day. Publications were sent to Cape Gazette on November 26th and November 29th. Coast Press for December 4th. Delaware State News for November 28th and November 29th. Mailings were sent out to property owners and signage was posted on the property.
Thank you. It sounds like everything is in order in terms of notification for these 2 cases. See Mr. Robertson here. Good evening. Are the parties here for the 38 Oak Avenue?
Yes, sir.
Okay. Welcome. Madam Clerk, has there been any general correspondence received since our last?
No general correspondence, only correspondence particular
To the cases? All right. There are no minutes for us to consider tonight, are there? All right. Is there any old business? That brings us to the new business, and our new business tonight is going to start with 19 Baltimore Avenue. As I mentioned a few moments ago, we have been asked to consider a motion for a rehearing. The original hearing was held in September, and you were aware we denied the applicant's appeal from a decision of the building inspector. The applicant filed a motion for a rehearing in a timely manner pursuant to the rules of the board. As far as I can see, the city has not submitted a response to that motion. Our rules require that we decide the motion solely on the pleadings submitted to us. We will not be hearing testimony or argument from the parties or public comment. So, the documents we have before us tonight are what our decision will be based on, solely upon those documents. Now, according to our rules, we can grant a motion for a rehearing if the applicant has shown in his pleadings one of 3 things. 1, mistake, inadvertent surprise, or excusable neglect. 2, whether there has been newly discovered evidence which, by due diligence, could not have been discovered at the time of the original hearing. Or 3, whether there's been an allegation of fraud, misrepresentation, or other misconduct of an adverse party. Now, we had a similar but not identical case to this come before us a couple of months ago. As in that case, I'm going to suggest that we move directly to the second criteria I just mentioned, newly discovered evidence. And I suggest to my fellow board members that the notice of the building inspector found at Exhibit B of the applicant's submission should be considered newly discovered evidence in the context of this case. I submit that had the applicant been aware of the notice the night of the hearing, he might well have been able to use it to his advantage. So it is my feeling that we should give him that opportunity at a new hearing to be scheduled at some later date if we rule in favor of his motion for a rehearing. Now, if anybody agrees with me on that manner of proceeding, we could entertain a motion to grant the rehearing and see what the vote is, and if it's approved, we would then schedule it at the earliest opportunity.
Just a point of clarification.
Yes, ma'am.
I think it was Exhibit C in the packet. I just want to be clear.
The document I'm referring to was a notification that was posted.
Right. And at least we get so many packets, but at least in this particular packet I'm looking at, it's Exhibit C.
All right, I can see what you're referring to, yes, and that's the notice I was talking about.
Yeah. I just want to make sure we're referencing the correct notice. It's the notice that was on the door that was dated September 24th.
It was B in the motion. So-
Okay, it's C in this packet, but,
It's the notice of the September 24th notice.
Okay.
So, now that we, does anybody think that that might be a way they want to proceed?
I agree.
Okay, so would you be willing to make a motion then?
Yes.
That we grant the motion for a rehearing? Do you make that motion?
I do.
Is there a second
I'll
to that
second it.
motion? All those in favor signify by saying aye.
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 All those opposed? Okay, the motion carries unanimously. We will have we'll have a new hearing on this. It'll be scheduled at the earliest opportunity.
Thank you. Sorry, I just want to make
That's all
sure
right,
that
that's
we reference the right notice.
Yeah, it was
Okay.
Exhibit C in the decision, the written decision. B in the motion, C in the written decision. Yeah.
All right, so now we're about to consider the case of 38 Oak Avenue. So who is here representing, or are the owners here? Well, would you mind joining us at the table? Welcome. We've introduced ourselves. Why don't you gentlemen take the opportunity to introduce yourselves?
So my name is Bill Nolan. I'm the owner at 38 Oak Avenue. To my left is Bob Purcell. He's the gentleman that oversaw the reconstruction, the renovation, and then joining me on the behind our two architects, Jonathan and Scott of C Studio Architects, and Bethany, who did the design, and the three of these gentlemen did all the permitting work, et cetera.
Okay, well, welcome to the board. Tonight's the opportunity to present your request for a variance. Now, as I looked at your application, what I see is that you have requested a variance, correct?
That is correct.
All right. And my understanding is you are seeking an area variance from the zoning code requirement that must provide 4 off-street parking spaces. So this is a pretty straightforward issue then.
It could be a little bit less straightforward if we let Scott say a couple of words about maybe the interpretation of the code, which may mean it isn't necessary for a variance if the code interpretation is different or misunderstood. Could we have the
Well-
opportunity to do that?
Okay, so what you're saying is that you want to argue that that there's discrepancy or disagreement about how the code should be interpreted.
Correct. And if-
Okay. That would be, there is a way to do that, and it's called an appeal from a decision of the building inspector. But you have not filed an appeal, as far as I can see, from a decision of the building inspector. You've requested 2 variances. You've requested an initial variance to relieve you of the requirement to have 4 parking spaces because of hardship. And I'm guessing one of you 4 wrote the addendum to the application.
That would have been me, yes, sir.
Would be you. And in that application, you said that it would be an extreme hardship to have to provide 4 parking spaces.
That's correct.
And the notices went out for the hearing indicating that you were seeking a variance, because that's what you signified on the application. Would you agree with that?
I do.
All right. So we're here tonight then to consider this as a variance.
That's fine.
Okay. Now, let me continue then. Under Delaware law, we must consider whether this parking space requirement results in exceptional practical difficulties in relation to your efforts to make normal improvements in the character of the property. The last paragraph of the building inspector's report says that you have, you provided the parking, or that the parking was already there. Is that accurate?
That is accurate.
All right. What is the exceptional practical difficulty that this provision would then cause for you?
The difficulty is that our original proposal was that we were under the impression that we had 1 dwelling unit with an accessory building. We originally removed the kitchen in the existing accessory building to what we thought was to comply with the code so that we didn't have 2 dwelling units on the property. And our original site plan, which I have all this information here, and I'd be glad to share it with you, but our original site plan that we submitted showed 2 parking spaces. It wasn't until we were trying to get our certificate of occupancy that we learned that we were required to have 4 parking spaces because the building official was considering our buildings to be 2 dwelling units.
Let me go back to where we were a few minutes ago. But by framing this issue as a request for a variance, we are locked into a certain legal criteria. And this is, I'm going to read you what it is. We have 4 things that we can consider because you have to be able to prove to us that there are exceptional practical difficulties meeting the zoning requirement. And these are the 4 considerations. The nature of the zone where the property lies, which is a residential zone.
Yes.
The character and use of the immediate vicinity. That's number 2. Number 3 is whether removal of the restriction on the applicant's property would seriously affect the neighboring properties and their uses. And 4, whether failure to remove the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. So, when you frame this as a variance request, those are that's the way the case was noticed, and those are the criteria we're going to consider tonight. So, you alleged that there was a great hardship by requiring you to put 4 spaces on there. But the question I have for you is, what exactly is the hardship?
Well, I think if I might add to that.
And I'm happy to let you talk. And everybody who wants to speak tonight is going to get the opportunity. I would just like you to introduce yourselves before you speak.
Sure.
As a court reporter.
Sure. My name's Scott Edmonston. I'm the president and principal architect of C Studio Architects. I think a practical consideration is that we really had no choice but to add the parking because of the late lateness of the notice. So if you look at the original site plan, the original permit application, the original approvals for the permit, it all indicates 2 parking spots. It wasn't until actually the Nolans were moving in that they were told they have to have 4 parking spots. So the exceptional hardship in this case, I think an exceptional hardship in this case is that the only way they could have occupied their house on the day when they had arrived from San Francisco, California, was to provide in a ad hoc manner 4 parking spaces, 4 parking spots instead of 2. So I understand your line of questioning, which is, well, there are 4 parking spots, how is that an exceptional hardship? Well, but the fact is that was never the way the lot was intended. It's not why they purchased the property originally. They purchased it for the open grass area that's within that lot. And if you talk about the character of the neighborhood, which is one of your considerations, if you look up and down that street, none of those houses have 4 parking spots. So I realize that, yes, it works against us that there are 4 spots already, so doesn't seem like a hardship, but none of the other lots on that street provide 4 spots. They were hamstrung into providing it that day, or they couldn't use their property, they couldn't move in. So they really had no option. They couldn't appeal, they couldn't do anything, and it's a situation we find clients in on a somewhat regular basis. And I'm not saying with the town of Rehoboth, or the city of Rehoboth, I'm saying with towns in general is, if you don't comply with this right now, you can't move in, and when you're talking about a summertime place, that's an issue.
Actually, they could have, if they took issue with the decision of the building inspector, they did have the right to appeal. So they could have appealed.
It's not about the right, it's about the timing.
Okay. Do you have a question?
Well, yeah, like, can the city address the discrepancy between the 2 on the original plans and the 4 at this point?
So the cottage out back was determined to be a dwelling, and at that point, we noted that, and this was during final inspection. This was probably around the August area. We noted that because the cottage was to be considered a dwelling, that would then bring in the 2 parking spaces requirement for that. 2 were located on site. We needed to provide 2 more.
And the original plans that they discussed, that they submitted, how was that back building characterized? And I realized what you see versus what it's characterized. I'm just curious how it was characterized on the plans.
It was reviewed under non-conforming, existing non-conforming. So basically, everything was existing at that time. The building department missed the interpretation for the dwelling, and we did not require 4 at that time.
But did they do what they said they were going to do in the original plan, or did they change it?
The construction was to the plans that were approved.
So, just so I understand, because I like to keep it simple so I understand it. They applied for it with 2 parking spaces, and they built exactly or close to what they said they were going to build. And then on the final inspection, it was determined by the city. And if what I'm saying is wrong, you'll tell me, because to me, because that did not come out in what was filed. What I know about this case is what I've read, and nothing. I'm familiar with the property, but I don't know how we got there. Is that true or not true, or lend some additional clarification, at least for my part?
Sure. I would like to retract one of my statements. I do not believe that we called it final inspection. I believe it was an inspection for something other than the final. I believe it was the inspection beforehand. Maybe we were out there looking at the shower. But the contractors at the time, and I'm just speaking towards the end here right now, the contractors at the time were notified on site that these were going to be part of the requirements to go forward for their CO. Why it was missed at the beginning, I cannot speak to it, other than we were reviewing for existing nonconformity, and we were mainly paying more attention, of course, to the building itself and the replacement of the building, and noted that they were significantly reducing their coverage on the lot that was existing from non-conforming.
So that's a couple,
But before we begin, excuse me a minute. I neglected to advise that everyone who speaks tonight on factual issues has to be sworn. So we're getting into some factual issues here. There are Bibles on the table. I'm going to ask you to put your right hand on the Bible and swear that the testimony you're about to give tonight, the truth, the whole truth, and nothing but the truth.
I do.
I do.
Okay, so you all from,
I need the names.
and the names, let's start with you.
Sure. Matthew Janis, Building Inspector.
You, sir? One more time? Each
Bill
one.
Nolan, I'm the homeowner.
Jonathan Selway, architect.
Robert Purcell, builder.
Scott Edmonston, architect.
Okay.
so this gets complicated because of, discussion of dwelling versus dwelling unit and the parking things, but, so you reviewed it for, under non-compliance.
Correct.
Does it currently meet code for lot coverage FAR? I know it doesn't for setbacks.
Right, so that was the reason for the existing nonconformity was the setbacks and the
setbacks.
multiple buildings on site as well. The rest of the building comes into compliance with the construction. The lot coverage comes into compliance. They reduced their numbers for that, and everything else was to code.
And so even putting in the curved path of parking that they have now keeps them within the lot coverage requirement.
Correct. They were approved for their certificate of occupancy. All numbers were in line at the time of approval.
Okay, and the parking gets kicked in for dwelling or dwelling unit,
Correct.
not just dwelling, and they're the two different definitions. Dwelling, the dwelling unit is located within the dwelling, so I don't have a question as to whether the parking's required or not because of it being the dwelling and the dwelling unit, but the question then is more deeper with the whole discussion on how many spaces they were required originally versus now.
Can I add something to that, though? So I think it's relevant, and it's something that did occur, the fact that the first plan showed 2 spaces, but then during an inspection, it was learned that there was a second dwelling unit requiring 2 more spaces. I was trying to find a case, can't find it right now, but I think your counsel will probably confirm that when a building permit is issued, if it's illegally issued or invalidly issued or issued in error, that doesn't somehow give it validity.
Right.
So once these guys discover that there's another issue on the property, they don't have they don't have discretion to say, oh, we missed it at the first round, now, so therefore the permit's valid. They don't have that discretion, and the law will support that they're required to impose that additional condition.
Right.
I believe that's correct, but the way we got to this line of thinking, we're trying to establish was there a hardship or not? And they gave us some information that at least I wasn't aware. You did, Matt, you did say that it wasn't at the final inspection, it was at some earlier inspection. Was this a day before the final inspection, a month, 6 months, or how long did they know where they could have chosen to go a different route if they were aware of it? Because where I'm reading it, just simply put, they didn't cause it, they were presented with it. Now, they may have been presented it earlier than what they're saying. When did they know about this?
I'm going off of memory here, and I believe it was a week or 2 before the final inspection had occurred.
But
Did that answer your question?
Yes.
All right. Any other questions?
well, I mean, I guess ultimately this comes down to 2 dwelling units or 2 dwellings, depending on which way you term it, with the kitchen or not having the kitchen, on one lot that triggers the parking. I think everybody knows how strongly I feel about the parking. The other piece of that is that they're able to get it on the lot, and you're able to get it on the lot by, the short pavers, small pathways. It doesn't have to be a concrete pad. So I'm back on hardship. It might have been uncomfortable having to do it at the last minute and, within a week or 2 or whatever, but I still need to hear a better argument about what hardship, because The hardship to me would be you couldn't complete your house or, things like that. But I haven't heard where the hardship comes in by the legal definition, because you're able to provide it. Might not be the, bucolic setting that you wanted, but you're able to provide it.
Can I add, and I realize this isn't the point that we're arguing, but that it has come up, the dwelling unit. And I do think it is a hardship that the way it's being interpreted, that there are 2 dwelling units on this property, because there aren't. And it's the dwelling unit that triggers the parking requirement. And a dwelling unit, as defined both in the International Residential Code and in the City of Rehoboth Zoning Code, requires space for cooking and eating.
No, dwelling or dwelling unit.
Either one requires
Why
the.
don't we do it this way? I kind of moved the discussion along a little bit. The building inspector had a report. If you'd like to give your would you like to give her your presentation?
Sure, absolutely.
Why don't we do that?
Took a lot of time to write it. Good
You don't
evening.
need to read it, but why don't you tell us what your argument is?
Sure. I think I'll just touch on the key points here. Obviously, the applicant seeks to either remove the 2 parking spaces or have the rear building not considered a dwelling or dwelling unit. Alternatively, they also seek to merge the 2 buildings together, which we will get to later. Based on section 270-4, the cottage conforms to the definition of a dwelling. In our code, a dwelling is defined as a building or structure which is wholly or partly used or intended to be used for living, keyword, or sleeping by human occupants. That's the definition for dwelling. Dwelling unit goes into the definition for a kitchen. Approved plans denote a bedroom being located within the cottage. Therefore, the cottage should be considered a dwelling. Then that kicks into, obviously, the parking requirements for a dwelling or dwelling unit. In 270-35, it states that all residential units, including accessory structures used as dwellings or dwelling units, require a minimum of 2 parking spaces each, bringing us up to the requirements of 4 parking spaces for the structures. It's important to note that a carriage house does exist on the property, and it is my belief that the measurements meet the 9x18 requirement. So essentially, they would only need to locate 3 parking spaces on their property. However, for that cottage or the carriage house to be considered a parking space, access needs to be provided to the carriage house. Alternatively, the applicant seeks to merge the 2 structures by considering a breezeway or covered walkway. While the walkway does exist today, the addition of that trellis or covering will add to the floor area ratio, which does put them over the numbers at the current plan that they submitted. Both the architect and I have agreed at 23.5 square feet. That would be in addition to what has been approved and certified for occupancy. And that would bring the FAR total to 3257.5, which is 13.5 over the allowable FAR for this lot. The coverage, because it basically exists right now, it's like a travertine or patio, stepper type patio. There is some grass space in between, so the coverage would increase incrementally, but it would be nowhere near the overages. It wouldn't be over the allowable coverage. It's also important to note right now that as we sit today, the residence does have all 4 parking spaces located on their property. Okay, good. Okay.
Yeah,
Question, does the 4 parking spaces that they currently have, does that include the carriage house, or the carriage house plus 4?
So they get a little bit of credit on this one because the driveway does have to go to the rear of the property where the carriage house is located. It's my opinion that they probably have 6 or 8 parking spaces located right now because the driveway has to go back to the carriage house.
Do you have a formal presentation, or do you want to just pick up where you left off there?
We'd be glad to pick up where we left off. We thought that we started out formally, but that's fine. There's a couple of points that I would like to make about our situation and the hardship that's created by this design of the parking. On the left-hand side of the property, you can see, I assume you all have a site plan that we've submitted that's the final. You can see that the fence is 2 to 3 feet inside of our property line. And we did that in order to accommodate and not aggregate our next door neighbor who would have lost their parking if we had moved that fence to the line.
Which, oh, the site plan?
Is this
Sorry.
easier to follow? Is this what you're referring to? or-
Yes, sir.
Okay, hang on.
Easily push that back over.
Okay.
We all have it, so.
Do you see the fence that goes down the left-hand property line?
Yeah,
It's in 2 or 3 feet. And that was to accommodate and continues to be accommodating to the next door neighbor on the left on lot 34 so that they can have their parking. If we had moved that fence to the property line, they would have lost their parking on that lot. And we were trying to be good neighbors in that respect, and that's how we worked around that. By
you were being a good neighbor.
Can you clarify, though, how,
You
how they,
succeeded.
yeah. Can you clarify how they would lose their parking by putting in the fence?
I'll clarify. So the property line is 2 feet, the fence is 2 feet inside of the property line. They have a driveway that goes from the street, from Oak Avenue all the way back to their garage. That driveway runs right along the property line. So if we were to put the fence on our property line, they don't have 9 feet of width.
So you were being a good neighbor. It was really a very generous thing to do. But how does that mean that you can't put 4 parking spaces?
Right, so good question. So all the plans that had been approved up until August of 2019, so we're going back to November of 2018 onward, included parking which went along that fence line. So we had just a straight parking along the eastern side of the property. And that parking could have extended for 2 to 4 parking spaces. It would have been fine, kind of out of the way, no problem. And that's how it was always drawn. That's what we had essentially lived with for the better part of 9 months. And ultimately, again, in August, when we were about a week away from moving in, we received notification that we needed 4 parking spaces. And because the fence line, which we had moved in to accommodate our neighbors, was set 2 feet into our property, there's a tree on the property that essentially made the existing parking spaces that we have not wide enough on our own property.
So how many feet is it from the fence, the existing fence, to the tree?
Matt, you might be able to answer that. I don't have that on a scale drawing here, but we do have the tree drawn. And I also want you to consider the fact that what we ended up with was the 3rd iteration of a site plan after reviewing on-site. Let me finish, please.
Let me get my answer first, and then I'll be happy to let you move on to the next subject. So the question was, how many feet from the fence to the tree?
Less than the width of a parking space.
Was it less than 9.9 feet? Is it?
I believe it was 9 feet 2 inches, and it's supposed to be 9 feet 8 inches, something like that.
No, it's just 9.
Yeah, 9,
I
sorry.
think
So
it
so
was- I think
we
it
were
was
6
under
inches,
8 feet. It was 8.
we were
Well-
6 inches outside of it.
But I'm waiting with you. I'd like to know, I mean, is it 9 feet? Is it 9 feet 2? Do we know?
It was less than 9 feet. Because we couldn't do it. We redrew it. I have it right here. They asked us to redraw it. We redid it. We put the new parking space in, and then they rejected it because the auxiliary parking spaces were too short.
Who's they?
The building inspector.
So the building inspector told you that you couldn't go along the left side of the property where we have that fence. Is that because of that tree? Is that what you're telling me?
Yes, but that was after it was installed. So it was part of the plans, it was drawn on the plans, it was installed, put in place.
I got you.
Okay.
So,
Can I share this with you?
sure.
So I just want to be clear. What you're saying is that there's less than, do we have confirmation that it's less than 9 feet? Are we guessing?
As far as the tree location?
Yeah.
So this is a document, this is a signed off and sealed survey. I would trust the surveyor's location on this.
Well, I know, but I'm not seeing the distance between the tree and the fence. That's what we're,
I would estimate it to probably be around 9 to 10 feet. I don't have the scale with me.
So how wide does the driveway have to be?
A required parking space in the city of Rehoboth is a 9 by 18.
yeah, 9
9
wide.
feet.
Correct.
Okay. So what I'm wondering then is, couldn't your 4 spaces still go along the fence, between the fence and the tree?
That would certainly have been a better outcome, but we were told it was not, we were told by the building inspector that it wouldn't work. That we were told to take it out.
Matt, can you comment to that?
Yeah.
Or the question was, I'm sorry?
No, the discrepancy is, the question that was asked from up here is, couldn't you just put the parking along the fence line back to the carriage house in a straight line? They're stating that they were told by the building inspector, I don't know if that was you or whatever, that that wasn't allowed.
No, we would have not said that that parking arrangement was not allowed. As a matter of fact, when we arrived on the site for the first 4 initial parking space review, when they were able to modify it, they had actually stacked the parking on each other. So in essence, one side set of wheels for a vehicle would be parked on another side set of wheels vehicle. So essentially, the parking space would have measured like 6 feet instead of the required 9 feet as they went down through.
So whether or not the building inspector, there's a dispute about whether the building inspector told you that you couldn't build a have a driveway along the fence, between the fence and the tree. But if you could, what's the problem with that?
Well, it's twofold. Number one, be happy to do it. I'd put 2 parking spaces in there, no problem. Putting 4, I think doesn't make sense.
No, but the question is, what's the problem with putting 4 along the fence line?
Just what I said.
Why
yeah.
doesn't it make sense to put 4 along the fence line?
We have 8 parking spaces along the front of the house, plus those 2. That'd be 10 for a home with 5 bedrooms.
Now, you tell me you have 4 parking spaces in front of the house.
8. I'm sorry, I said 8.
Parking spaces. Is that located on your property?
No,
All right. So you don't own the property that you're addressing,
no, but I did improve it.
thank you, but
You're welcome. I'm happy to do
you
it.
are a nice guy. I can't.
But the general public can park there.
I'm sorry?
The general public can park there.
Absolutely.
So, back on then the hardship, because that's what we're going to keep coming back, because when we grant a variance, it's a permanent thing. It goes with this property forever. That would mean that going forward, you could, whether you disputed if it was a dwelling unit, if the property was sold and someone wanted to convert that, you'd end up with, 2 full living areas, which you have now, and not the required parking. So I'm still struggling with needing to hear a little bit more of a hardship rather than a lack of desire of wanting to do it. Because the law requires us to grant it based on hardship, not on lack of desire.
Yeah, I mean, I think, as I understand it, and it was read to me, and I apologize, I don't have the issues in front of me, but there were 4 criteria that you consider in regards to a variance. A hardship was one of them. Am I mistaken?
No, hardship is the main criteria. and
Sure.
there are 4 factors that we weigh to
I see.
consider the hardship.
Do you have the 4 factors? Anybody have them?
Yeah.
Yeah. We just want to take a look at it.
Sure.
I don't see them here.
When we made the attempt, on that drawing that you have right there, where we made the attempt to go beside the tree, we actually put that in, and it was rejected by the building inspector because the parking spaces were not big enough.
And I suspect what I'm hearing, I want to clarify this, is that they were, because you didn't take it all the way back and you were trying to stack it because the spaces need to be 9 by 18.
we couldn't take it all the way back because we wouldn't fit between the fence and the tree. But I do not know what that dimension is, I'm sorry. But I know that the building inspector wouldn't allow us to do that, because we actually put those parking spaces in, and it wasn't sufficient enough.
I believe the dimension is 8 feet 6 inches from the tree to the fence. That's the dimension I remember.
Well, I guess we're not going to settle that issue tonight, but you have a strip of land that maybe is 9 feet, maybe it's 8.6, maybe it's 9.2. But the strip of land that goes along the fence that might be suitable for 4 parking spaces.
But the building
you're- and-
inspector wouldn't allow us to use those.
I hear what you're saying, but that's not what he's saying.
I don't, maybe he needs to see that site plan, because that's who rejected it.
I think it's
We
also
actually put it
important to point out that sorry to interject, but if that was brought to our attention earlier in the project, different decisions could have been made with the project. So the plans were approved with surveys and site plans showing 2 parking spaces. We had multiple meetings with the city before we even submitted for a building permit. This never came up. The existing plans of the cottage were included that showed an existing kitchen, bathroom, bedroom. And if that information was known ahead of time, Mr. Nolan could have made a different decision with the design to accommodate what he ultimately desired for the property, which was a really nice grass open yard that the house was designed around this yard. So the issue or the hardship in my understanding is really the timing of finding this out at the end when all of these decisions had already been made, including moving the fence 2 feet into the property.
And I'll just add on to that. I think all of these first of all, I respect the job that you guys do and what you have to do. And we come here because we've been coming here for 30 years because we love it. And when you look at a property like this, I think you have to look at the entire project and everything we've done. And if you think about it, by granting that easement to our neighbors at no cost to them, we essentially enabled them to keep 4 parking spaces. We also improved the property in front of our house. Bob has a picture of it, but if you can see, this was the house before the renovation. You can see that it's all grass in front of the house, immediately in front of the house. And what you can't quite see is that there's one little paver driveway, and to the left of it is just overgrown brush that went all the way to the street. You couldn't park there. We've put aggregate across the entire length, all 75 feet of the lot and a half. So we went from having a property that you could park. You had 1 real parking space. You probably had 3 others on grass that would be a mess in the mud, et cetera. To now, today, you can park 8 cars in front of our house. We'll maintain that. It's aggregate, et cetera. And then we've allowed our neighbors to keep their 4 parking spaces. So I look at it and think we went from having a house with 6 bedrooms, a full kitchen in the back dwelling in this back cottage. We ripped out the entire kitchen. There's no kitchen there anymore. We reduced the number of bedrooms in the house from 6 to 5, and we expanded the number of parking spaces, again, not on my property, but just through improvements. So now there's 8 public parking spaces in front of our home. There's 4 in our neighbors that they would otherwise not have, and I'm happy to put parkings along the side of my home, but I would submit that I would wager that probably for the next 20, 25 years, I don't ever expect that we're going to need to park on that yard.
Let me ask you this. So this property now, it sounds like you have 5 bedrooms in the main house.
No. 4 bedrooms in the main house, 1 bedroom,
One in
one's
the carriage, or the cottage in the back. And how many baths do you have in the main house?
4 full and 2 halves.
Is this a property that you use as a weekend home for yourselves, or do you rent it out?
Historically, we rented it out through Lingo. We haven't decided whether we're going to rent it out going forward.
So you've been renting it out. And when you rent it out, do you advertise it as a 5-bedroom,
Lingo historically advertised it as a 6-bedroom.
as a 6-bedroom? And Is it a weekly rental or?
Weekly, memorial to labor.
So when they advertise it, 6-bedroom or whatever they say, how many people did they say it can accommodate?
I believe 10 to 12.
10 to 12 people? So do you have any idea how many cars actually are typically?
Oh, absolutely. Yeah, typically between 3 to 5 cars.
Okay. So you do have 3 to 5 cars associated with your house when it's used for rental purposes?
Well, again, we've reduced the number of bedrooms, so we've taken it down from 6 to 5.
Okay. So your house, maybe your tenants could possibly use 4 off-street parking spaces?
I haven't decided whether we're going to rent it out. Yeah.
But, sorry. I mean, but you, future owner, somebody, I mean, again, when we grant variances, we have to look not just at the current situation, but the future, because that stays with that property
course.
forever.
But again, so let's think about that. So we had 6 bedrooms, now we're down to 5. Can sleep 10 people. If it was 5 couples, which frankly it never is, that's 5 cars. I've got 8 parking spaces, public parking spaces in front of the house. And if you were to add 2, if you were to have 4, that's 9. I'm sorry, that's I can't do the math. 12. But 10 for 10. I mean, you'd essentially have 8 public and 4 on premise for 10 people.
But I think it's a little unfair. To me, it just doesn't sound right for you to claim benefit of the 4 public parking spaces.
The 8 public parking, and I'm not claiming them. I'm simply saying that I'm trying to do the right thing.
You made 4 beautiful public parking spaces, but.
8. Oh, wait, 4
Hey,
additional, correct.
But they are public, they're open for the public. Are there any other questions regarding,
Can I also submit the original site plan that was approved?
so is this the document we have here?
No, I believe it is.
Okay. So you handed me this one, and this is the original, so you want these 2 to come in?
Well, what I'm trying to show you is we had to do 3. This is the original one that we did that was approved.
Okay,
This is what we worked out with the building inspector, and then, once we put it in, it wasn't sufficient enough. And then when that one failed, after we put that in, this is what we came up with to accommodate that, because they used the carriage house as an extra parking space.
all right,
So
so
in order for us to get there, we go around a tree, and,
here's what I'm going to do. This was number 1,
yes, that was the original.
number 2,
Yes, sir.
and number 3.
Yes, thank you.
All right? So why don't we do this? I'm going to ask the clerk, can I hand this to you? We'll make this one joint exhibit with the joint exhibit 1, A, B, and C, okay? How do I sound reasonable? That's part of the record now, okay?
Thank you.
You're welcome.
Do we have any, I'm trying to look off the drawing for scale, the distance from the front of the property back to the carriage house? I'm assuming this is this a 75 by 100 lot?
It is.
So as an estimate,
80?
I have a scaled set of drawings here, if you want.
yeah, could you tell me what the distance from the front to the carriage house is?
So 32, 3, so roughly 32 feet from 100.
77 feet?
66. Yep.
66 feet.
67. Yep. It's, yep. 68 feet.
What was that, 68 feet?
Oh, sorry.
It's 68 feet to the carriage house, so it's not enough to have 4 parking spaces up to the front of the carriage house. The carriage house doesn't have, because this was discovered at the end, the carriage house didn't have a door big enough to accommodate a car by the time we knew that that was a requirement. So while the building is big enough to fit a car, the door into it wasn't designed for that. So it was a 6-foot door, it wouldn't fit a car. So in reality, the carriage house, unless we redid the carriage house door, would never fit a car. and the fence was already in place that limited the distance on the side of the carriage house, so you couldn't run the parking along the side of the carriage house.
But what was submitted, or what is on there now with the curved, so that we're looking at the same plan, that is that 4 spaces now, or is it 3?
Probably close to 5.
I would say it was more closer to 5 if you would use the rounding and the radius of it.
Okay,
Yeah.
so the bottom, I mean, there are ample
Yes.
spaces on the lot as it sits today.
Yes.
Okay.
But again, I just want to make the point about that. That was the third iteration, right? We lived with the 2 parking spaces for 9 months. Beginning of August, we were told, no, you need 4. And we, in conjunction with the building inspector, said, well, will this work? And we agreed, if you do X, Y, and Z, yes, we'll prove it. So we did what we agreed upon. That was Plan 2. And then at the 11th hour, with, certificate of occupancy expected, hours away, we were told, no, you have to do something different. So the curved was a jerry-rigged solution that we came up with in, hours, just to try to get the certificate of occupancy.
And keep in mind, those last 2 weren't plans. They were actually put in. Those driveways were put in.
Installed, yeah.
And we had to rip them back out we were under the gun to get these people in their house. So in order to expedite this and get these people in their house, we just did it. At a cost that was exorbitant to rip the driveways out and put them back in and to remove them and then to get it resurveyed, and we couldn't get the certificate of occupancy until the survey got done. And we had to resurvey each time those strips were redone.
So if I could speak to survey number 2, that was the one where I was speaking about.
Is there, can we get copies if we're going to talk about things?
So we're talking about that last exhibit, the 3-part exhibit we just entered? right?
Yes, sir.
All right, I'm going to suggest we take a 5-minute recess and ask the clerk to make half a dozen copies of that exhibit, please, so we can all have it.
Anything else you think?
You're in recess for 5 minutes.
Yeah, I hate talking about plans when.
Thank you, Madam Clerk, for giving us these copies. So where were we? Where were we? We all have copies now. You were referring to these?
Yes, sir. Number 2 is the second iteration that we did. I guess you called it,
1B.
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 that's the second iteration that we put in the ground that the building inspector came out and denied. So, and the reason that he denied it is the depth of the parking spaces front to back, because by the time we got to the fence, we didn't have enough for the parking spaces front to back, which will be left to right on that drawing, and then the other one's going straight in along the fence.
All right. So here, now I got a question for you now. Let's look at 1B and 1C, okay? If we look at 1B, we see the distance between the tree and the fence. Would you mind looking at it? You see that? And it looks to me like those,
I don't have one
We
anymore.
don't have it anymore. You have it, yeah.
I mean, I have a pretty good one, but.
Yeah, but we know it, I think.
you know,
right there.
it looks to me like those vertical lines are meant to be wheel marks or paths for wheels to follow. You see what I'm saying?
I do.
Okay. Would you agree with me? That's what what those lines are supposed to depict?
Yes, sir.
Okay. And we see that those wheel marks go between the fence and the tree.
Yes, sir.
Okay. So it would appear from that picture at least that there is enough space between the fence and the tree to put a driveway. Yes, sir.
Can you ask your building inspector that question? Because he's the one that rejected it after we put it in the ground.
Can you answer that question?
I do not recall the parking space going back beside the tree. What we went and out and inspected was out in front, where you pull the car in and you would park the nose towards the front of the residence. Those were the parking spaces they were claiming, and when we put a tape to it, they did not measure the 9 by 18 spots.
So they would be the two that are running parallel to the street, basically.
Correct.
Correct.
So let me ask you another question for either of you. Before you did this construction of putting these different spaces in, did you go back to them and say, will this work, or did you just put them in?
Met with him on site.
Yeah, yeah. It was in communication with them. They agreed that that would work, that 1B would work.
And I want to make it perfectly clear that this was not an antagonistic relationship. This was working together to try to resolve this problem. But when we did it, it was rejected after we went over this, after we met on site and put a tape measure on it with the building inspector. For some reason, it was rejected after it was put in the ground. With all due respect, this is not a proposed site plan. This is an actual as-built. Each one of those is an as-built. Do you know the difference? I'm not trying to talk down.
No, we got it.
Do you understand the difference between them?
But
Matt?
we're here for a variance tonight.
Well, I think that speaks to hardship, right? I mean, so we talked about, and I don't think anyone on our side of the table is trying to argue that just because it was approved on the permit, that it should be approved. We're just trying to say that, you know, the timing of it does create a hardship, and what we're left with now is parking that doesn't meet the nature or the character of the zone. It was a hardship based on the timing. So if you look at the rest of the neighborhood and this house in particular, there's a beautiful large tree. There was an open yard there, and now there's parking weaving through that. And if you imagine 4 cars parked in the middle of that yard, that's not the nature of the Pines at all, and particularly that block of Oak Avenue where each house has maybe 1, maybe 2 spots at the most. What we're looking at is we were designed the original house around this open yard, around this beautiful specimen tree, and now what we're left with is a field of parking between the house and the tree.
So you're saying, I'm not trying to put words in your mouth, but you seem to be saying that this is an aesthetic hardship.
Well, it's not, no, I don't think it is. I mean, I think it's a use hardship, but I mean, I think the aesthetics have to do with it because you are supposed to consider the character of the neighborhood. So if we talk about the character of the neighborhood, you don't have parking in this manner in any other house in that neighborhood. And then when we talk about whether it's seriously impacting the neighbors, what Mr. Nolan could have done is moved his fence, seriously impacted his neighbors, and put 2 spots or 4 spots between the tree and the fence. We're saying that the parking that was installed between the fence and the tree was rejected. For whatever reason, it was rejected, had to be ripped out and redone. I would consider that a hardship as well. You know, what we want in the end is an open yard, the way that the house was originally intended to be done. And however we can get there, we're open to working with you. And if that's saying amending the variance to say, hey, can we just have 4 parking spots, whatever the width is between the fence and the tree, I think we would be agreeable to that too. We just would,
4 parking spots between the fence and the tree.
at whatever width that is, understanding that we're pretty sure that's within 6 inches of the width of a parking spot.
It's a different variance. I could do that. I could do that. Or I can move closer to the mic.
Sorry, I was
I
sleeping
was
on my
getting
job.
I was getting too comfortable.
Yeah, I mean, I think,
So what you're making a face, but I'd like to respond to him. So he's saying, if we could do the 4 between the fence and the tree, you would do it. Is that what I heard you say?
I think, obviously, ideally, we would like to have 2 parking spots. But I understand where you guys are coming from. I think we understand where you guys are coming from. We want to be good neighbors. We don't think 4 parking spots is justified, but if that's the way you guys are interpreting it, then yes, I think we would be willing to go to 4 spots.
Okay, so let's pursue that a little bit. There's a couple of ways that maybe that could occur. One way would be that we adjourn and we don't consider the variance request tonight. That there be, I could be talked out of this, but we don't have to make a decision tonight. We could adjourn, discussions could continue, and if they're not fruitful, we could come back at some later date to continue this. But some people might think you made a good suggestion.
Conversely, we could grant a variance of the width, but still require the 4 and be within the prescribed ruling that we could make
I see
today.
what you're saying, but that's not the specific variance they requested.
Amend it right here if we need
It's-
to.
Then the application was for a variance from the section that describes the parking
Parking.
requirement. And I mean, I think we could hear from the city on that, but I think an argument could be made that notice is sufficient to allow
Sufficient
for
to do?
this consideration.
Okay. All right.
And while they're pondering that, I've got a couple of questions about this fence that you've located inside your property line. That is your fence, right?
Correct.
And it's not shown on any of these drawings, but those pavers that are your neighbors, they don't encroach on your property?
I'm not sure. They could potentially. I just don't recall.
And they don't have a fence, right? There's no fence there. So is that a paper problem that they have with meeting the minimum width of their parking, or is it a
No,
real problem?
we tested it out. We put a car on there, and if you put a fence on our property line, the car just wouldn't fit between their house and the fence.
It's a difference between like the wheel width and the actual
Right,
practical
right.
driving width, like the mirrors and the width of the car.
There was also an existing fence in roughly the same location that we replaced.
And that was but it was your fence?
Yes.
You know, one thing I've learned about doing this particular job is that you can come to a meeting expecting that you know what's going to happen, and then it doesn't happen. Other stuff happens too. And I appreciate judges who require lawyers to tell them everything before we go to a hearing, but I think that we have something to consider here, and let's try to talk. Are you willing to modify your variance request to say that you'd be willing to, you would accept 4 parking spaces along the fence between the tree?
Yes, if we could do it tonight.
Okay, so there we are with that. Now, would you speak against that, or would you take a position on that?
Well, so in a variance request, it's typically been the city's position, and it is in this one as well, that we don't have a strong, it's not an adversarial relationship. We don't have a strong feeling one way or the other about the outcome. We do expect the board to apply a certain legal standard, and should they meet that burden of proof, then you should grant the variance. So as to, the only issue I see here is the notice for tonight's meeting talks about whether a structure will be considered a dwelling or a dwelling unit, thereby requiring 2 additional parking spaces. So the ultimate issue on the notice is about whether there will be only 2 spaces required or not 2 spaces, or 4 spaces required. If that's sufficient, if your council thinks that that's sufficient, we're not going to take an issue on that either. Ultimately, it's your decision that might be jeopardized by the notice.
Well, that notice almost makes it sound like it's an appeal as to whether or not that's a dwelling or not a dwelling, which it is not. So it is relief from the parking requirement that's being sought, which was characterized by the chairman correctly as an area variance at the outset.
Okay. So is that the way you'd like to frame your variance request tonight? To be able to put 4 parking spaces along the left side of this property, I guess that's the easterly side, to run between the fence and the tree?
I was going to say, I don't know that you can get 4 in there. That was back to my original question. It's only 68 feet. You need 36, 72. So we'd have to give both a width, which we don't know how much, and a little bit of depth.
Yeah, or we could do 2.
That's 11 feet, right?
Oh, yeah, the parking would fit between the fence, we think, between the fence and the carriage house at that same width.
With the width.
So it could go all the way back to the.
Yeah, but it only goes, that's what I asked you originally. It only goes back, you think, 68 feet.
That's to the front of the carriage house. You could go-
Okay, great,
You
great,
can
got
put
it.
a car there.
You have more room.
You'd have to go
Gotcha.
past the carriage.
Oh, and
Yeah.
Is that the way you'd like to frame your variance request?
Yeah.
Okay.
okay.
All right. Is there anything else from the city? Anyone from the public like to speak for or against this particular variance request? Madam, would you please come up? And I'm going to ask you to stand at that microphone, identify yourself, and swear on the Bible that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. There's the Bible.
Do this first. Edie Heron, 36 Park Avenue, full-time resident of Rehoboth Beach. My husband Jim is with me. I swear that I will tell the truth, the whole truth, and nothing but. A couple of points. We're not actually for or against anything. We welcome new neighbors and are looking forward to meeting the Nolans. But I wanted to clarify a few things. 46 Oak, in the last 2 years, had a very similar situation. They had a 50 by 100 foot lot. Their project was very similar, it seems to me, from the outside, as 38 Oak. They didn't tear down the existing house, but stripped to the studs and rebuilt. Their rear cottage does not have a rental license and is not eligible for one, and is also pretty basic. But they still had to have 4 parking spaces. We have no comment on whether this is a good or bad thing, or if there are no rental license on the property, but it's the code. The other thing I wanted to mention was that this is a little bit from a letter that Jan Conacy sent as part of the comments earlier today, or yesterday, and we added our name, as did several of our neighbors. And I wanted to mention that one of the support letters, one of the first ones that came in for Mr. Nolan's variance, was from the Spillmans who live next door, whose fence you're talking about. They're the ones at 36 Oak. So they're next door, they're 38. So they're one of the people who right away said they wanted to approve this. As I said, we're not necessarily for or against. I just want to clarify some things. This gentleman thought that there weren't, at least from what I understood, the gentleman, the pink, is it Scott? He said that, I thought he said earlier today that there were no other situations similar in the neighborhood or that he was aware of. I'm letting him know that the one that I told you at 46 Oak seemed to be a similar situation as far as we know, being neighbors and hearing what goes on here in the neighborhood. Jan, I liked the final comments of Jan's letter here. She says, so how did this happen? There was an architect and a very experienced builder involved. Weren't they aware of code requirements in Rehoboth? Now, we've been hearing there's been an iteration of perhaps some misunderstandings between that we weren't aware of before we came in today. If not, they should have been aware. The time to deal with these wants is before, not after the building process. If they'd connected the two houses from the beginning, there would be no need for the 4 spaces at all. We all make choices when we choose to live in town Rehoboth Beach rather than Henlopen Acres or North Shores. We live with the traffic, the crowds, and the building codes of, that we live in. It's the sacrifice we make to live in our very, very special, unique, tree-lined beach community. We're not sure of how all this happened, but we feel it's a bit unfair to ask the neighbors to sit in judgment on each other, either for or against. Homeowners ought to be able to depend on our wonderful building and licensing department and the Board of Adjustments and our building inspector to uphold the code in their best way and to enforce it fairly and consistently. Variances seem to be for hardships only. And most importantly, builders and architects should understand the code before they begin working in Rehoboth and explain it very thoroughly to their clients. That could solve a lot of issues and help homeowners in their decision makers. So,
Thank you for the comments, but let me tell you something.
Yes.
We're all volunteers here,
oh, I know.
okay? And we struggle and we work hard to be fair
I know you
and
do.
consistent, all right? So we're doing the best that we can, and we're not trying to skirt it, cut any corners. We want to follow the law and do the right thing.
And I hope
Okay.
that's what I'm imparting to
Well,
you.
I take issue with the last few things you said. It could have
I
gone,
think Jan said it.
well, whoever
Jan said it, but
okay?
we agreed. I mean, we
All right.
wrote in, we agreed. So
But
anyway, thank you for letting
your
me speak.
comments. Anybody else care to speak for the public? No. Now, we do have some correspondence. It's in our packages. Do you want to tell us who the correspondence is from? You don't want to tell us. You want me to tell? You want me to announce it? All right. Somebody find that for me,
No one's
please.
cooperating with you tonight.
Let me see if I can find them all. Here we go. I think I do. All right, we got this one.
All right, so we have a letter from Elizabeth and Mark Kreil, and those are the people our previous speaker was referring to. They live at 40 Oak Avenue. Then we have and they're in support of the project, as was noted. Then we have a letter from Paul Carano, 45 Oak Avenue.
45.
Yeah, he's not in
Okay,
support.
and he says that he asks us to treat you in a fair and consistent manner, which we're trying very hard to do. Okay, and so that's a letter that we got.
And he was opposed.
He was opposed.
I can't tell. what
Yeah,
he-
down,
Yeah, he was opposed.
I am confident I think he's saying, you know what, I'm just going to read the whole letter. There's some dispute. Dear Rehoboth Beach Board of Adjustment members, as property owner of 45 Oak Avenue, I'm responding to the letter sent to me concerning my neighbor's zoning variance request for 38 Oak Avenue. I'm supportive of any action the Board of Adjustment takes on this variance request, as long as my neighbors are treated as other neighbors have been treated, asking for similar FAR and parking space variances. The details of the request by owner and the building inspector's report seem to differ on the definition of dwelling versus a dwelling unit. I'm not sure which definition should apply to the guest house, so I'm not sure if it's a dwelling or not. If it's a dwelling, then it should meet parking requirement if the code requires it. That's the Board of Adjustment to decide. I would have thought the issue of parking requirements would have been clearly understood by all parties at the time the building permit was granted, but that might not have been the case. In general, I am not supportive of granting FAR or parking space variances for newly constructed homes. My neighbors across the street, 46 Oak, had a similar nonconformance new construction home built a few years ago. They had a similar second dwelling situated in the detached half garage. They put in a long driveway along the side of the home as required by code. Please treat my neighbors at 38 Oak in a fair and consistent manner, requiring them to do what other neighbors have done, or grant a variance if that what has been done for others in similar situations. The building department has a difficult and thankless job upholding the city building code. We should support their decisions if they are correctly interpret the building code. I am confident the Board of Adjustment will do what's right for my neighbor and the city of Rehoboth. So that was signed Paul Carano, 45 Oak Avenue.
And then that's Jan.
Then we have the letter from Jan Conacy, which was read into the record by one of the speakers.
Well, you don't, I recommend you not read.
Did you told us most of it, right?
And then this is someone who's in support of Jan's letter.
Then we had a letter supporting Jan's letter, and that came from Edie Heron. That's you, all right, so we have
And
that.
there's another one supporting.
Then we have a letter from Karen Medford supporting Jan Conacy's letter.
And that one's supporting
And
Jan.
then we have a letter from Sandra Wells agreeing with Jan Conacy's letter. So that's the public correspondence that we have had in relation to this hearing. We've heard from the public. Anybody on the board have anything they want to ask? For further comments or questions?
No, just comment. You know, I feel very strongly that, particularly in new construction, we have to meet the parking requirements, and I feel pretty strongly that the parking requirements are clear in this with 4. However, I think that it's reasonable to, with the compromise that was worked out, that if, and we don't know the exact width of it, but if it turns out to be 7 feet 6 inches or 7 feet 8 inches, which sounds to be about what it might be, that would be a reasonable compromise for a variance.
Okay, so if that's the last comment on this hearing today, now we find ourselves in the position where we have to fashion a motion, okay? This is going to be a little tricky, so don't get agitated. But one of us or all of us are going to have to come up with a motion. The motion, I think, is going to have to be framed something like this: to grant a variance to the owner to allow parking along the east fence of the property, to run along that fence between the fence and the tree, okay, to provide 4 parking spaces on the property. Council, what do you think?
I think that's,
You think-
I think that's
Do you
good.
think that's
I
sufficient?
think it
That's
gives the
good.
building official
Okay.
So the motion I'm hearing is,
motion he's asking for.
He's asking for
I'll make a motion to grant the variance to allow for 4 parking spaces that would be constructed along the east line of the property, along the fence, between the fence and the tree, going back as far as needed to create the 4 parking spaces required by length, and allowing for those few inches of width.
All right, is there a second to that?
I'll second,
that's-
okay,
that's-
I'll second that.
All right. All those in favor signify by saying
No,
aye.
no, you have to, remember, you have to, it's a variance.
Excuse me?
You're going to need to ask individual.
It's
for
a
an
variance.
individual
Okay.
Roll call
You're
vote
right.
and
I'll do,
support.
thank you. Walt,
I'm in support.
Lou,
Well, hold on.
I'm in support.
you have to
and
give reasons.
And give your reasons.
Because they are providing the 4 required parking spaces that's required for this situation here.
Lou?
I'm in support of this, that they are providing the 4 parking spaces that originally should have been required, but given the circumstances, I think this is a reasonable variance request.
Vice Chairman?
Um,
Vice Chairperson?
I'm in favor of it. I believe that the 4 required spaces are being met. I think that creating a little bit less width around a tree doesn't create any difficulty for the neighborhood, and therefore I'm in favor of the variance.
Okay, and I'm also in favor of the variance. I think that any width difference between the tree and the fence will be de minimis, and I think that there has been a hardship here, perhaps due to miscommunication with the building inspector's department, but some work was done at expense to you to try to comply with the rules of the building inspector. But I think that this variance that we're voting on here tonight resolves that in everyone's favor. So you're gonna we'll have 4 parking spaces off-street, and you'll be able to keep most of your property clear. So I vote in favor of it as well, and it passes 4 votes to none. Okay?
Thank you.
Thank you.
Thank you.
Is there any other business to conduct tonight? Then do I have a motion that we adjourn?
Motion.
Second?
Second.
Second.